Participants, so welcome. And Hannah, you want to just get us started?
Yes, of
And
course. Sure thing. So as we're going through this, just the same as applied for the Q&A, just for the people who are hopping in here, if you have a question, we would highly recommend, if you would like, for it to go through privately, to click the Q&A button that's at the bottom of the screen between the participants and the chat button, so that we'll be able to, maintain some type of confidentiality, if at all possible, by maybe rephrasing the way in which the question is answered. And so for this, everyone's camera will be off except for Mr. Martin and Craig. So Mr. Martin, I give you the floor. You're more than welcome to get us started, okay?
Thank you, Ms. Hannah.
Thank you.
Okay. Good morning to everyone. So my name is Martin Schweiger. I'm a patent attorney in Munich and in Singapore. And I wanted to introduce you today to the UPC land. I have coined this word because UPC land is not just another way to look at Europe and its countries for getting patents. I wanted to I wanted to highlight to you, since the 70s of the last century, right, there have been the efforts to create a uniform European patent that could replace all the national patents. And when I say that, I mean, in Europe, we don't even have a federal patent as you have in the US. We have state patents, a bit comparable to the state trademarks that are common law trademarks, right? So, and when patents and patent litigation and is quite difficult, while we have a uniform way to get the state patents over the European Patent Office, which is currently doing outform work for the national patent offices, the state patent offices. Now we have the European Patent Office really as handing out a federal type patent that is valid in all the associated states that come together under the UPC system. The UPC stands for Unified Patent Court, and it comes as a package together with a unitary patent. This is the patent that I just have mentioned. That package created UPC land, in my perspective, because I think that it's better to look at it as a new land, as a new country, than as a new patent system, because it not only comes with a single patent, it also comes with a court that can grant injunctions and damages for the entire UPC land, and that's very different from before. About myself, I'm in the patent business since 1993. I love very much patenting computer algorithms, and you find my name all over the internet when you Google for that. I'm also, I love gearboxes and patents for that, and I'm a founder of a law firm. Let's look at now geography. I really have 30 slides and we don't have much time, so I give it a tough ride and you ask me questions later, or Craig, if you want, then interrupt me. This is how Europe looks from a bird's view. The European patents that the European Patent Office grants can take effect up into 44 countries. And the 44 countries, only 39 of them are in Europe. And as you see from the map here, this is the European Peninsula. There's the large chunk of Asia here. And in addition to the 39 countries that are on the European Peninsula, there are 4 countries that are validation states and 1 extension state. And one of those states is in Asia. So in Cambodia, you can get a European patent. What an irony, right? But also in Morocco, which is Africa, and also Tunisia here. And then there is, of course, here please don't ask me, that could be Kosovo, but I'm not sure. And then this is Moldavia, which is near the Ukraine. This is where the Ukraine war is currently happening that you see on TV. So quite a lot, right? Then this is a bundle patent. Then we have the unitary patent, a single validation at the EPO, and unitary effect will cover many states, the blue ones, right? And now let's compare one single patent court. the European patent potentially has 700 million people, but I have never seen in my lifetime a patent that is valid in 44 countries. There may be some in pharmaceuticals, but I'm not sure whether this is the case. Here on the UPC land, you have 295 million people. That's a bit less than the US with 330 million or 350 million currently. So same size population-wise as the US, at least from a magnitude thing. Now let's look at the global economy. Pareto applies. 1% of the countries, no, not 1%, 4% of the countries do 50% of the total business because it's fractal. The US, China, Japan, Germany, and now India, these economies have a GDP of 50% of the world GDP. And then in the second league, there is France, Canada, Russia, the UK, and Italy. UK was at that position until last year. India has taken over. So now let's look at that. UPC land is the third largest economy in the world after US and China. And the UPC land is different from those still growing. UPC land has about a GDP of 13.4 trillion US dollars. China, a little bit more. And then the US is really a whopper, is so much bigger. So that's really something. But at least the third of the world's economies. UPC land states maps. The dark blue ones are those that have already ratified the UPC agreement. It's in force from 1st of June. And there's a sunrise period since the day before yesterday where you can activate or not. Then the lighter blue colors, they are to come hopefully soon, because that would add countries like Ireland, larger ones like Ireland and Hungary, Romania. And then there are the ones that still have a problem with the translation is Croatia, Poland, and Spain. Spain being the fifth largest economy in the EU and only not taking part because of the language and of course of some national other issues. Why would you have a central court that enforces, gives injunctions and court decisions about something that should be decided by a national court? So for these people, it's difficult to overcome the idea that the national states would surrender some of the rights to a larger organization, a bit comparable state and state law and the federal law in the US. The question is the UK in the UPC? No, it's not. I cut this short to save time because today I don't indulge in that. No, the UK left the EU and therefore they cannot be a UPC country. Only a unified patent court country. They can still fall under the UPC, but they left. So they completely, in order to rejoin the UPC jurisdiction, they would need to rejoin the EU and then ratify the UPC agreement. Again, to be very clear, only EU countries can become UPC. Fall under the UPC jurisdiction. But all other European patent attorneys can represent people before the Unified Patent Court. So you can have a Turkish patent attorney represent a US patent owner before the UPC against the UPC defendant, for example. Now, European filing strategies. Craig asked me to how do we get into Europe, and I would like to give you a bigger view of the big picture here. Europe is about 46 countries, right? Of which, and if you, I've taken here the Wikipedia data. I summed it up. The total GDP is 24.6 trillion, which is larger than the US economy, which is only 23 trillion, is also large. So Europe is economically, the whole of Europe is comparable with the US, but is not unified. Wars are ongoing are just over in 4 of those countries. There's Russia, Ukraine, Georgia, and Kosovo. So Georgia had a war with Russia some years back, and Kosovo, they had a war with each other because Yugoslavia split up, and then the Kosovo wars where they all fight against each other. So this is not ideal when you want to do business, right? So the question is now, to me, where do I file in order to get 50% coverage of those $24 trillion GDP? Because that's my first and foremost goal. I want to file my patents where the business is. And a very good indicator for business is GDP, because these are the more wealthy countries with a high GDP. So in order to get a 50% coverage in Europe, you can either vote for the unitary patent. If you have the, I don't know how many unitary patent countries we have, should be some 16 or so, if I'm not wrong, but don't nail me on that. I need to look it up. These countries give you 53% coverage of the total GDP of Europe, or you could go for a European patent and then validate in Germany, in the UK, in France, and in Italy. That would give you 52% coverage, plus the costs for translation into Italian, because the Italians still want a translation. You don't have that translation for the unitary patents, because Italy is a unitary patent state. Of course, that's the second, the more costly variant here. Or you take the, if you want more, you take the unitary patent plus you validate the EP patent into the UK. That gives you 66% coverage, and you have no translations, but what you get is the extra renewal fees, annuities for the UK part of the European patent. Or if you want even more coverage, then you would get the unitary patent and the EP patent that is validated in the UK, in Switzerland, and in Ireland. That would give you 71% and no translations. So these are the four, I can already foresee, these are the four most favorite options that people select, and especially those who do not want the Unified Patent Court to have jurisdiction over their patents. Then they need to go for the second option here, because only in this option here can you opt out of the jurisdiction of the Unified Patent Court. You need to have a European patent. You cannot opt out the unitary patent from the jurisdiction of the Unified Patent Court. Yeah, and the important thing is these options are all available on one single form from the European Patent Office. Yeah. One more thing, yes, you can have up to 3 parallel patents in one and the same country for an identical subject matter. I give an example in Germany. There's a national patent for Germany. Then you have a bundle, EP, DE patent, or a unitary patent. And you have a utility model, is a little or a petty patent, which is very, very powerful, especially because of a definition of the prior art that is very similar to the definition of the prior art in the US. So for most applicants of the US, a German utility model is an option, and also the other utility models in Europe, especially if you file after you have used your own product in the US before you file the patent, leveraging on this grace period. Again, in order to obtain a unitary patent, you can file a conventional application at the European Patent Office. You don't need to file a different application or something. The decision of whether or not to obtain a unitary patent will be made at the time of grant of a European patent. And no, you cannot add EU countries to your unitary patent if that EU country ratifies after your unitary patent is granted. You will then also have a bundle. Then sunrise period has started on March 1st, 2 days ago. Opt-out can be done individually or in bulk of the European patents of your choice, published or already granted. You can also do it with applications. It's already possible since January 1st, 2023. You can request a delay so that you can get a unitary patent. So if something, a European patent is to be granted in the next coming 3 months, and if you want unitary patent protection, you can delay the publication of the mention of a grant. you can request early unitary effect, but I have not found a practical application of that second aspect, but it's mentioned all over the place, so I repeat it here. Where's the Unified Patent Court? It's not a one single building. Like the federal courts, is all distributed over the states. And you see here the green dots. Most UPC land states have a Unified Patent Court, although some combine the courts into, like the northern Nordic countries, they have one place in where is it? Finland has one here. Is it in Finland? Yeah, probably. And the interesting thing is, revocation is always done at the main department, the central division, and the central division is in Munich and in Paris, and very likely very soon in Milan. You can see here, Milan is the local division, and very likely the Italians will get the third central division from that was with the UK before they left the EU.
Hey,
English,
Martin?
yes.
Can I jump in and ask a question?
Yes, yes.
For us Americans, we're not familiar with the term revocation as much. So is that, so there's, I divide the world up into two. There's patent offense and patent defense. Patent offense, what we usually think about when we think about taking our patent to court, we're thinking about suing somebody for infringing our patent. In this case, we're talking about somebody infringing our patent in one of these UPC states, in the UPC land or Europe. That's offense. So we're taking our patent rights and we're offensively, saying, hey, you're infringing my rights, and we're protecting our rights offensively. But when you do that, the defendant, the accused infringer, has a counter argument, and they can say, hey, wait a minute, whether or not I infringe the patent, your patent's not even valid and should never have been issued in the first place or granted in the first place. Is that what you mean by revocation? Is they try to say whether or not I infringe, your patent's not even valid. Your patent should be canceled. Is that what you mean by revocation? Is that what that's sort of a defense to patent infringement?
Yes. I'm not so sure about how this is handled in the US, but what I hear from the many articles that I read is that a typical way when someone's user out of a patent in the US, that you get into inter partes review proceedings. And these inter partes review proceedings are currently done at the US Patent Office, and then there's an appeal to the Federal Circuit, I believe, and then you would have that, and then the patent would survive or not. And that same measure is available at the court. And that's a thing from the common law patent infringement, that the same court would decide on the revocation of the patent or the limitation of its extent based on new prior art that is presented by the defendant or by other defenses. There are as many as 17 different reasons for revoking or deleting or canceling or erasing or whatever, banishing a patent. And the good thing in the Unified Patent Court is that you do this in the same court in many countries of the world. Actually, yeah, all non-common law countries, they have this bifurcated way. In China, you have one court for revoking patents, in another one for the infringement. In Germany, you have the Federal Patent Court, which is there for revoking patents mainly, and also as appeal instance for decisions from the German Patent Office. But in Germany, you have bifurcated. You have the normal the district courts for the infringement as first instance, and the Federal German Patent Court for the revocation. And of course, a standard defense in common law patent infringement is, as you say, yes, plaintiff, we hear you. Your patent claim may read on our device, but the scope of protection of your patent claim is far too large because there's this prior art that you have not taken into account. And these revocation actions, they are dealt with in the central division. And if it so happens that you sue someone at the place of infringement, let's say in Portugal because you like Portugal so much as a holiday country, and then the infringers use back for revocation, that would be in one of the three central divisions, either Paris, Munich, or Milan. And then you usually, this is what I would do as an infringement judge. I would refer the case to the central division that is also handling the revocation. So you end up automatically there. But in print, I mean, theoretically, you can have the central division handling the revocation and the local division handling the infringement. But is not yet there,
Okay,
but
so
I can tell.
the point is, this is very complicated and it there's a lot of layers to this. So the whole point of this workshop, the background, there's all this litigation strategy that comes from this, so that you as a business owner, you know, you don't need to understand all these levels.
Yeah.
What's great about Martin, just like exposing this, is because there's so many layers to this. But he's boiled it down into a go, no go decision, an opt out yes or an opt out no decision.
Yes.
And he's got some strategies that, you know, because there's a deadline coming up on June 1st, which is, you know, a couple months away here. And this whole system is going live, and people who have a dog in this fight, if you have a European patent, or you're headed towards a European patent, now's the time. We have a short window of time to make this decision.
Yes.
And we're not going to try to understand all the European court stuff in the architecture of it today. Now you understand it's complicated, and Martin understands it. That's the important thing. And he can guide us on a business strategy when you get to that point. If you're at that point, or coming to that point, or thinking about it, we have a top guy here who understands all this stuff. He's a litigator. He's on patent in Europe and Asia, and he's been doing this for 30 years, and he really understands this stuff very, very well. And so we're very lucky to have him guide us through this and boil it down. He's very business oriented. He's not just a patent, you know, geek. He's a patent geek, but he's also a very savvy business guy. And he can boil it down to, you know, what you as a business decision maker need is what do I need to do? You know, which box should I check? And then then his firm can take care of that in that country, because it's outside the US. So, you know, he's qualified to do that. I'm not. And so we're bringing in Martin because he is like the top European patent attorney, as far as I'm concerned, that I've ever dealt with in 23 years. And I've dealt with a lot of them. So anyway, I just wanted you to see this is complicated. We have the guy, and he made it real simple. And we'll talk about that in the end here. But I better let you continue on.
Okay. Why am I talking so much about Unified Patent Court? Because there are people out there who seriously do not want to have their patents under the jurisdiction of the Unified Patent Court. And I don't understand, because I'm very pro Unified Patent Court. I think it brings many more advantages than not. And it would make sense to rather swallow this and prepare yourself for litigation in a federal system, different from and the reason is that the Unified Patent Court has technically trained judges of German, Dutch, and Nordic origin, and if you look at how to say, if you have craftsmen or work mentality, then in these countries you find the painters who also paint behind the door where nobody looks, right? And in other countries they just paint where you can see. So if I have a German, Dutch, or Nordic origin judge that is technically trained deciding over my patent, I would feel much more comfortable. And you never know where you end up when you go to a French or Italian court or so. In Germany, you have very smart and also technically trained judges, but that's not the case all over Europe, in very short words. So then you can also select the court venue, but that slide is also intended for lawyers, and I believe you're businessmen here. So I focus from now onwards more on the business side. The thing is, UPC provides mixed common continental law style litigation, which means you combine infringement and invalidity, but you avoid lengthy trial days in court. The goal is to have one patent infringement case, inclusive revocation, solved in one single day, and the whole procedure in a year or a year and a half. And currently, when I think about Germany, we talk about years. And when you talk the two decisions in talk about the two decisions in the two courts, we talk about 2 trial days currently. But they want to bring it down to 1 day. And yeah, this is if you want to know what look for netlist on the internet, on Google, and see what the bifurcated prosecution, bifurcated revocation and litigation does in the US. And in China, they also have the same problem. So the worldwide, the whole system goes to the unified handling of revocation and infringement. Unified Patent Court, 3 important takeaways. All UPC decisions can be swiftly asserted in the entire UPC land, and this is different from the EU. I just tell you, if you get a decision from a German court for a European patent that is valid in 5 countries, and you want to assert that decision in another country, that's close to impossible. You need to involve another court there just to get the thing asserted, and that's different in UPC land. You get it within very short time. UPC interim preliminary injunctions are immediately available, and that's different from the US and China, and you can leverage on this. There's nothing more powerful than an interim or preliminary injunction out of a patent, because you can send anytime a bailiff to the premises, business premises of your competitor, and stop them doing what they're doing, because it's handed out by a court. And that's if you're all business people, you need to change your mindset when you talk about UPC, European Unitary Patent, because it gives you a very sharp sword that is immediately effective. And I speak of experience because I do injunctions since 1996 in Germany, mostly of trademarks, I must admit, and very few from patents. But the good thing is, I have seen how that works. And I have also seen how injunctions are enforced in other countries. Like in France, the bailiff would come with a baseball bat in order to protect himself from the guys, because the French can become very emotional when it is about injunctions. So this is really efficient. And also, what is you in the under UPC and the unitary patent, you get 5 times the bang for half the buck as compared with the UK. The UPC land has a size of an economy that is 5 times bigger than the UK, and litigation in the UPC, Unified Patent Court, costs only half of the litigation in London in the High Court, and plus the appeal. So from a business perspective, this sounds like a no-brainer to me. If you give me the choice of between a bundle of European national validated patents and a unitary patent, I would always go for the unitary patent. But I speak here as an enforcement guy. I've done for 8 years the anti-counterfeiting for Mercedes-Benz in Germany and in Asia. From Japan over Australia to Southeast Asia, not China. Unified material case law, I need to write through this. All these are very sensitive issues that are decided differently in all the different European countries. There may be a different view of novelty, inventiveness, equivalence, priority, and so on and so on. There are even selection inventions that you don't have in the US, but you will need to learn as a new lever for doing patents when you work with Europe. I skipped this, it's really too far. In very short words, if you go under the unitary patent UPC standard, you need to prepare for litigate grade patents. And the litigate grade patent is very different from, let's say, an economy class patent that you only have because you want to have a patent for impressing a government official when you do a supply contract with them. This means convert US style patent claims to EP standard with independent claims in 2-part form, and so on and so on. You need a support section for each claim definitions, and each claim needs one advantage, not the whole. And you need technical effects. And you don't want this in the US patent because some judges, this is what I've heard and I've also seen, if someone builds a device that falls under a claim, a US patent claim, and the US patent mentions an advantage that comes with that claim, then if that allegedly infringing device does not have the advantage, despite having all the claim elements, does not infringe. I'm not sure whether this is true. Mr. Thompson, you are the US patent attorney. Please help my backward unknowledge. Yeah.
30 seconds on this. If you do it wrong, it's bad. If you do it right, it's very good. And if we have a system that has worked since I developed it about almost 20 years ago, it's worked beautifully to get more patents through litigation, what I call litigation quality patents, through the patent office faster, with fewer rejections from the patent office, faster for less money. So they're higher quality, they cost less, and they go through with fewer rejections. You get your patent sooner, it's worth more. So if you do it correctly, the advantages are absolutely helpful, and they benefit the European and other countries. You know, there's benefits in there. So we always include them. We 100%.
Yeah. I just want to say, as you said, if you do it right, then it's good. If you do it wrong, then it's not good, and you shoot yourself in the foot.
Right, exactly.
So,
that's right.
Yeah, whatever. So I write through this. I said already, right? I recommend to have a parallel US patent application be filed along with a new PCT application when you look for getting a patent outside of the US, and that conversion from the US to non-US or EP style can be done within 2 days. We'll talk about that later. Of course, there are some others, reference numerals in the claims, and you need support for intermediate, but that's all very lawyer techy stuff. Yeah, whatever. So to me, litigation grade UP, UPC, EP patent is somewhat like the opposite of litigation grade. But of course, Craig, you said that this is not the case. It depends on how you do it. But to me, as an outsider from the US, when I hear US patent and I wanted litigation grade, I'm all the warning lamps go on, and don't take my UP, UPC, EP patent and just nationalize it in the US, because this will end badly. That's my feeling. Am I correct?
Yeah. So the bottom line formula, I think that the winning formula is if you're starting in the US, is the way we draft it is the optimum, the best you can do, I think, and it's proven for decades now that it works really well. And it's, as I said earlier, but it's not optimized for European and, the maybe Chinese or Asian. So Martin is so good. He developed a process, and when we have a client who's at that stage, we can connect him with Martin in the appropriate time. It's a little bit off the UPC topic, but when you're going to prepare for going into the UPC, that he has a special process that he can add on and turn that around and do that conversion. And we'll do another workshop just on that, because it's so cool what he developed.
Yeah.
So we can't get into that today, but it's really, really awesome.
But it's also the other way around. It's not only for US to EP guys. We also need to do something when we want to litigate in the US.
Yep.
And I can tell you right away, now with the Unified Patent Court, the magnitude of work and money that is put into patent litigation is now so much bigger than as compared with before, that I think that more companies would see patent protection as a global issue. Right? And then it's not about how many countries do we need in Europe. In Europe, you need the unitary patent, and of course you need a Chinese patent, and then you need a US patent and the Indian patent probably, and that's it. And a Japanese patent if you do business there. But it's no, and then we talk about those 4 or 5 patents in this world. And and then it is more aware what is needed there. When you get so easily entangled in the woods in Europe, so that we have so far with our state patents, is probably you have recognized that I'm pro unitary patent. So conversion here, yeah, we talked about this. This is Latin. When we do a conversion, then of course we are used to work for US attorneys. We have a 2 days turnaround time sprint service for this, US dollar flat, and you get your work within 2 days. So you can even decide 1 week before the priority period ends whether you want that conversion or not. I believe that's pretty unique. I'm not aware that anyone else would offer that. So we go for speed. The sprint is the speed is what counts. The innovation is how much profit do you make divided by time. That's the definition of power. So the smaller the time, the larger the power, the innovative power. So I believe that we need to get patent protection quick and assert it quick. And it to me, a fast patent is worth so much more than any patent that I can have 5 years down the road. Actually, I find it quite boring if it takes 5 years. So forget opt-out, unless you do not want swift litigation. That's my main message today. You can opt out and in any EP patent as often as you like during a transitional period of 7 years after the start of the UPC system. And I can tell you already now that these 7 years will be extended by another 7 years. So 14 years, which is an eternity. All big players in the UPC land industry will not opt out. And I asked around, I'm so long in the industry, so I know most head of IP departments. And what I can tell you, all those from the engineering side, they do not opt out. They all want the unitary patent. Who is not opting out are pharmaceutical industry and biotechnology, because for 2 reasons. The marketing strategy is to cover the entire land, and because there's government involved, they want to have the state patents, and they prefer a state patent over a central patent. And also, currently only the states would give you an extension certificate that you can request if you do pharmaceuticals in order to cope for the 15 years of getting your new medical drug registered. And there's no unitary equivalent for that. So the pharmaceuticals, they will not do. But all the others, they all go for the unitary patent. Problem is also, if you opt out, it does not mean automatically that you are not at the Unified Patent Court. I will come back to that. There are many backdoors that would bring you still there, and your competitor can force you there. One valid reason for opting out is if you have really a crappy patent, then you expose yourself to a lot of unnecessary problems, because I heard that there are people out there who are looking for crappy patent, and then they blackmail the patent owners that have a unitary patent. In a sense, now pay us money or we request revocation of your patent. It's like a reverse patent troll business that is there. Crappy patents should not appear before the Unified Patent Court unless it's done in bulk. I wanted to present you a few crappy patents. A crappy patent for me is a patent that has only 2 pages or 3 patent claims, maybe not even a proper embodiment. You would ask me, who does that? And I can tell you there are patent filers who deliberately file crappy patents, and mainly in the car industry, because the KPIs that they have is how many patents did we file. And also there are others. I will come back to that. Then we have a sprint acceleration at EPO. This is, by the way, my personal website. It's different from my firm's website. I have a blog where I help patent attorneys, especially young ones, to be better perform. This is my calling. I'm also teaching at university, but of course, my favorite is being a patent attorney. But this is my blog, and I write all there. And I found also that in the meantime, I have kind of an influencer position in that area. So people read my blog. in that area. This is the EPO acceleration ground procedure, is explained in detail. So anyone who can read and take the course there, it's even for free, can do the same acceleration as I do. But as far as I know, we are the only ones who do it. The EPO track 1 sprint service for this is $5,000, and we pay money back if we don't make it within a year. Because we are so confident that we make it. And by the way, there's a little term that says we carefully look at the patent before we take it up into that program. There are patents that even we cannot accelerate. And especially if you start to discuss with the examiners about issues that should not be discussed in order to get a quick run. So now we are talking to opt out or not to opt out, and that's the tangled question here. And just to let you know, the ChatGPT, I put a heading to opt out or not to opt out, and I asked ChatGPT, can you turn this into a pun? And this was ChatGPT's answer. I don't know, I find it quite funny. I added the not here. So this is how far we get with artificial intelligence today. Example for good reason to not have the UPC jurisdiction for your patent. Your government supply contract is backed by a patent. And if you Google for Heckler & Koch and handle Sturmgewehr, you know Heckler & Koch, right? It's a very famous pistol and gun in Texas. Everybody has 2 guns or 3, I heard. I would love to live there. So there was a case where Handel was bought. Handel is a East German manufacturer of guns, and they were bought by a Chinese conglomerate. And they wanted to supply assault guns to the German Bundeswehr, the German army. And they couldn't because the bureaucrat who sits there in the purchasing department said, sorry, but Heckler & Koch has a patent for that assault rifle. And then Handel said, oh, too bad. And then the bureaucrat said, if you either you get this patent away or you will never be able to supply. Even we recognize that your gun is not so bad. And then Handel initiated revocation. And the patent was revoked. Now imagine you have a patent in all of the countries of Europe, as Heckler & Koch has, and you have a unitary patent, and then you lose all your supporting patents in one single trial day. And then you only have an appeal. And the appeal would only talk about whether or not there was a mistake in the decision, but they would never go back and reevaluate the evidence. And this is the true reason why many people discuss about opting out. They do not want, there's this fear, what happens if I lose my patent in one single trial day? And there's the appeal instance would only look at the reasoning of the decision, but never again at the evidence. And that's the core, the fear of losing what they have. And the normal industry company would not be afraid because you have more than one patent for the same product. And also the marketing is, whether you have a patent in one country or not, does not play a role. But in that specific case, a government contract in place, and the government contract is leveraging on a patent, that's a true reason to not be under the Unified Patent Court jurisdiction. I believe that was quite clear. So
that in that case, your advice would be to opt out.
Yes.
Opt out, yes. Okay.
Yes.
It's an opt out, yes case, but it's kind of a corner case, not real common. It's very niche to government contract.
I would say, yeah. Another one is, now let's look at pharmacy. Bayer AG, aspirin, right? Everybody knows aspirin, and Baygon is the thing against the bugs. And the head of IP in a recent interview, he said the following: the unitary patent is not attractive to pharma and biotech because they don't have the supplementary protection certificate. So if you're, I'm a mechanical engineer and an electrical engineer, and I don't deal with drugs much. I don't even know what a supplementary protection certificate looks like in practice, but I know that there are these out there, and people who have patents that get that should not go under the unitary patent, because for unitary patents there is no such supplementary protection certificate. Enough said, right? I believe. So until that SPC is in place, Bayer is not considering unitary patents for crown jewel patents. Crown jewel patent means they're the only ones who have a drug that can be sold in Europe. Of course, would they go for 46 patents? Although I doubt so. In the meantime, Bayer will include its non-core patents in the new unitary patent system. And I believe that's a very clear message, right? So if there's no need for the SPC, of course, unitary patent. Why? Because litigation is so funny, so simple and easy. Head of IP, Bayer is one of the largest companies in Germany, right? So and then then again, he's criticizing the European Patent Office because of issuing bad quality patents recently. I believe if a bad quality patent is issued by the European Patent Office, that's also the fault of the applicant. As an applicant, you can go for two things. Either you get a patent claim that is reasonably broad and covers the choke points of the products, where a point where everyone who wants to produce a solution has to go through. And if you have a patent that blocks that choke point, then you have won. And it doesn't matter how long or short the patent claim is if you have that choke point. That's number one. Many of the patents that I see that don't even think about the choke point, about business. Where do I sell it? Why do I need a patent? All what the patent attorney is trained to do is to get the maximum scope of protection, that with your bicycle patent, you can also sue an aircraft manufacturer. And to me, from a business perspective, this is simply unrealistic, because I have never seen anyone suing a non-competitor out of a patent, because simply we have so many other things to do. Then most business owners do not have a patent troll mentality. They just want to do a better business, and they have a patent to protect the blue ocean that they have found from the competition coming in and then turning it into a red ocean. I hope that you all know the Blue Ocean book. I have it here. This is something that is essential. I think people who don't know the book and do business shouldn't be there. I have it there because I need it so often to explain to clients or startups who do not know that. Anyway, so of utmost importance is that your patent will likely survive revocation. And that's not only the burden is not only on the patent office, but also on the applicant who pushes a patent through. And of course, if you're consistent and insistent enough, can you get a very broad protection? But the question is, does it really help you if it goes to court? And the answer is no, it doesn't. And as the first one who wrote a book exactly about litigation grade patent is Craig Thompson. That's why I'm here today. Craig, your book is also here. Oh, where is it? Here is your book. And I recommend it to everyone. If you have not read that book, please do so now. Yes, yeah. To my knowledge, Craig was the first one in the patent industry worldwide who talks about litigation grade patents. Or do you have better prior art, Craig?
No, I was working for the Fortune 500 and I was totally contrarian.
Yeah.
So
Yeah, but to me it makes fully sense, and I have examples from my own professional life. You have a patent that is drafted according to what the infringer does, and the secret was filing a continuation patent and then drafting a claim that is 1.5 pages long, but has all the features of the competitor's product. You go to litigation, this patent will survive anything because the patent claim is so long, and it would still read on the product because every feature is fulfilled because you knew the infringing product before you drafted the claim. And that's something like a magic bullet to me, and it's an eye-opener. And I've learned it 25 years ago from Mannesmann patent attorney, in-house patent attorney. He told me that. And since then, I always, and you were the second person that I met in my professional life who's promoting that actively. And even before you file, doing all the analytics that you do before drafting. So yeah, that's in short words. Good.
I'm cursed to be an engineer and we have to do it, you know.
Yes. And
Yeah.
also talk business language, because, yeah, what is a choke point for an engineer? Huh? So good. Cliffs ahead. So if you really still want to opt out, I have a warning for you. If you opt out cheaply, then that may fire back on you. And I give you a few examples. An erroneous opt-out application will have no effect. You will get a certificate from the Unified Patent Court registrar that you have opted out, but that certificate can be worthless because if you have not done it the right way, it's not valid. And the default is that the opt-in. It's not possible to correct errors after an action, an infringement action or a revocation action, has been commenced before the UPC. Actually, opt-out would only help you against revocation action. So this is where it's important. So if someone requested revocation for your unitary patent and you are not opted out, then you are at the Unified Patent Court. And even if you think that you have opted out, you will be surprised when you're still there. And there are several ways. Required is a full compliance with the Rule 5 of the Rules of Practice of the Unified Patent Court, RUPU UPC. The information provided must be accurate. No checks will be made by the UPC registry. In the event of an error, you can lodge a correction, but the opt-out will only take effect after the date of correction when you have fulfilled all the requirements. So you can try to opt out after the revocation action has started, and it may be opted out, but it's for the current ongoing court cases irrelevant. So be careful. If someone offers you the opt-out for a cheaper price, there's always someone who does it cheaper. Important, the UPC will not check by itself whether there is any opt-out declared. So it could happen that you have opted out and still you get a revocation action served from the Unitary Patent Court. And only then you would be surprised. Why do I get this? It's because the Unified Patent Court does not check. In a revocation action, the onus is on the defendant before the UPC to raise an objection that a valid opt-out has earlier been done. And you would be surprised if there's no objection in time and you only have 1 month, right? And be careful, you are in the US, and until the revocation action has been served on the local representative and then reached you in the US, 2 weeks are gone. And then you have 2 weeks left for opting for raising that objection. If you don't raise within a month, you're opted in. If the objection was done by the wrong person, default is opt-in. Who could be the wrong person? A person could be someone who at the time of raising the objection does not have a valid chip card. There's currently a big woo-ha in Europe because the UPC is up and running, but there is no chip card. So I personally don't have a chip card for acting at the UPC. It's not a problem because by 1st of June I will have one. But it could be that the chip card is expired or whatever, something is wrong. You cannot fax an objection to the UPC. You have to file electronically. So default objection is done by the wrong person, or even you think, oh, I'm the owner of the patent, I can at least raise the objection that I'm opted out by doing it myself because I want to save money. No, you will be opted in. The opt-out was done in an invalid way. For example, you name the wrong proprietor. It could be that the unitary patent has been assigned, or the European patent, because the opt-out is not only for, you cannot opt out the unitary patent. The European patent has been opted out from the jurisdiction of the Unified Patent Court. And that national patent was assigned from the earlier owner to a new owner. And that assignment could happen because, for example, your subsidiary in Germany has changed the status from private limited to another, something like a listed company, and all the patents are still under the name of the private limited, and then you opt out in the name of the listed company. That opt out is not valid because the listed company was not registered as a new owner, or there is some other issue, like you have a co-filing with a corporation company. Simon, you're cooperating probably with someone when you do the registrations. So be careful who is listed there. And if you want to opt out, that must be carefully found out. Again, you cannot opt out. I say it 10 times today. You cannot opt out a unitary patent from the jurisdiction of the Unified Patent Court, but you can opt out a European patent, which is different from a unitary patent from the jurisdiction of the Unified Patent Court. There are many more surprises to come. If you give us European patent attorneys only enough time to become creative. So I would never be sure whether my opt-out is valid or not. And there's no way to find out until someone files a complaint against for revocation of a patent. Why are you laughing and giggling, Craig?
You're very creative, Martin.
Yes, I am very creative.
Creative among all European patent attorneys.
The default is opt-in. And why would I opt in if so many practical reasons are against opting out? My opinion, don't opt out, but still do your due diligence about the patents in your portfolio, because that's important. If you show up with the wrong patent in the Unified Patent Court, it will only end badly. So remember, opt-out is for live EP patent applications and granted EP patents only. It's not for unitary patents. It's not for national patent applications, not for utility designs. You call it design patents, right? Or for petty patents. Remark, and it's also not for associated supplementary protection certificates. Tactics, unitary patent and the UPC or not. I will recommend a very conservative two-step patent strategy. Step 1, evaluate whether the respective patent or patent application is worth the effort at all. And a patent that is not and will never be useful should be dumped as soon as identified to be so. And that sounds like a platitude, but it's not. Because when I look at the portfolios that I see of our clients, there's so much to clean up and so much money to be saved by just looking at it and not being there. I know it's boring and it's not nice, and you need to find out what are my products and is this patent still covering that, and what was the motive for filing that. It costs you an hour or so per patent. And now imagine you have 150 patents. Do you spend 150 hours to clean up that? Where to take the manpower? And then what happens if the decision is not right? Would I pay my patent attorney to do it? No, of course not, because it's too expensive. But we find ways in order to find it out easily. So there should be an annual house cleaning of each IP portfolio. The step 2, will it hurt you more if you lose your specific EP patent for all UPC states? That UP is wrong. You cannot lose. It's right. You can lose your unitary patent for all UPC states in one single action, as compared with losing it state by state. So you can lose both for all UPC states, the EP and the unitary patent. But of course, the opted out EP patent can only the opted out EP patent can be lost state by state, not the unitary patent. This is normal for 99.9, and I would even add 99.9999999% of the cases. Losing your specific EP patent for all UPC states in one single legal action would not hurt. To the contrary, it would help. And you do not qualify for an associated supplementary protection certificate. If both applies, then you are part of the 99.9999999%. And that means you do not need to opt out from the jurisdiction of the UPC. Nothing needs to be done with your existing granted EP patents and your pending EP applications, except you want to do it right. Steps for opting out, and you will need all of them. So if you decide that you want to opt out, you give us a list of your EP patent and EP patent applications in Excel format. Optional, a list of your products and of your inventors together with the relevant EP patents and EP patent applications for these products. That's all what we need. We do a status check of each patent in the official registers. That means we make sure that we opt out for the right people. Optional, a reasoned decision to let it live or not based on your optional information above. And the information above that you give us can be given by your accountant. It is so simple. The accountant would be in a position to tell us. You don't even need a product manager or an executive. The accountant would usually have that information. Number two, we compile and send a list of rights and entitles owner to the person providing instructions. That would be the person in your, probably the accountant, along with declarations to be signed, because we need a declaration from the owners. And so we need a proper power of attorney, in very short words. And that's one more reason why you may think that you have opted out, but you have not opted out. The attorney who opted out didn't have a power of attorney, a written power of attorney. And if it was a written power of attorney, was it written in the right language? Is the signature readable? Is the right wording in the power of attorney? There are so many reasons. So also what we do is we chase that person to provide instruction for collecting the formal agreements from all entitled owners. So that's a follow-up. When you send a person that is busy such a list and the documents, they will put it on the back burner usually. So there is some chasing needed. And you won't do it by yourself, so we do it for you. We find out, we will ultimately file the opt-out application. When all signatures are received, there's a certificate, which is worthless, by the way. We update your personal IP rights online database with the evidence of proof of filing. If you don't have one, then we can give you ours for free. We have a database, a very simple one, where you can put your protective rights in, not only patents, but also trademarks and designs and registered designs and design patents. And yeah, so we will have you. And we do this together with a proof of filing, because you will need the proof of filing if someone objects, if you want to object if you want to object against a plaintiff who tries to pull you before the for the Unified Patent Court. You will need that information. The certificate does not help. I don't even know why they issue a certificate. It's a bit like a confirmation of receipt. The certificate has zero value. The price for the steps 1 to 5 on our side, and that excludes the US patent attorney's side, is 386 flat for small numbers of patent applications. Large numbers is a different issue, but this is our bottom line. And to be billed separately is the preparing list of the EP patents if you don't have one. That's something like a private investigator's work. And also update the register at a later time when we find that the register info in the register is different from what it should be. So now, what to do if you do not want to opt out? I just amend
this
this
is what
text.
you recommend. This is what you recommend, 99.99.
Yes, this not opt out. This is my recommended step. 99.99999% should do this. So I amend the text. You don't need this, but you better do it, all of them. Then we will not file the opt-out application, and the price is not 386, but is 286. And that's the recommended thing. That's for the people who also paint behind the door where nobody looks. That's very German. If you do not want to opt out at all, the cheapest and easiest is just to do nothing. Leave it as it is. These are the people who file crappy patents and don't care. They are not informed about, they are not informed clients. And just by the fact that you are here today present, I count you as informed client, you want to improve, you want to know why you have your patents and what you can do with it. I can tell you that you, as you are here, the yellow box is not for you, because I give you another reason. I want to do it properly, because my estimation is by doing the house cleaning now, you can save 50% of your total renewal fee expenditure right now, within like this. Why is it 50%? If you have old patents that are obsolete, and the chance that patents are obsolete is higher for an old patent than for a young patent. Also, the renewal fees increase exponentially for the old patents. So when I look at the portfolios, 20% of the patents cause about 80% of the renewal fee. That is the Pareto rule. And these 20% are most of the time the old patents. So on 20% of 20%, which is 4%, they cause 80% of 80%, which is 64% of the renewal fees. And 20% of 20% of 20%, Pareto is fractal, which is 0.8% of the patents. So if you have 100 patents, then there's one patent that causes 50% of the renewal fees, because you have so many countries and it's so old and the renewal fee is so high. If you just kill that one, then you can reduce your renewal fees by a tremendous amount of money. That's why I really recommend do your house cleaning now. House cleaning or housekeeping, whatever. You get a personal IP rights online database that will help you to save money in the future. You make the annual housekeeping very efficient. You provide your personal e-file for each IP right, inclusive the opt-out information, what has been filed, which you will need, and then making payment of future renewal fees very efficient, because there are ways to liaise with your renewal fee provider or even for the attorney, because one button would give you a list of what has to be paid for the next month. Rule of thumb, the opt-out or not exercise will save you so much money that the costs are paid for even if you do not opt out in the end. That's a very clear insight that I have when I look through my clients on our side. So they will all go for the opt-out or not exercise without filing the opt-out request. And yeah, that's the core, I would say. And then there's a smart idea. You can also monitor the opt-out of your competitors, and the fact that some competitors choose to opt out only some of their patents rather than all reveals that they are of particular importance to them. And that is not my idea, but I had it in a discussion, and that to me, it says everything about the people who recommend the opt-out. They are fearful to lose the patent in one single go in one trial day. And I don't think that this is a good motive for deciding whether or not you opt out. That's it. I'm through.
Okay, great. Thank you, Martin. So if you have any questions, please type them in the Q&A. But just to wrap up here, I know we went long, but it was very, very valuable. Thank you, Martin. I'm going to tell you, we have a special bonus for you today for attending. It's good until midnight tonight for you if you want. I think it's very valuable. So I'll tell you what the bonus is first, and then so let me share this with you here if you can see this. All right. It's if you choose to sign up today with Martin's program, with our help, we'll support that and do some of those pieces for you and help you collect some of that information and put together the patent filings and the ownership and stuff that he'll need. But in addition to that, just for attending this today, if you do take advantage of that, you'll get a free workshop ticket worth $447. Timothy and I are putting together, we've innovated a new tool called a foreign filing decision tool. And it's very, helps you make a business ROI based decision on a country by country basis rather than just giving you here's, what typically happens is here's a list of countries that, and you just say, how much is each country? And there's no real developed thought there. And it doesn't give you as a decision maker a very good basis for making a decision other than a list of prices next to a list of countries in a 2-column table. This is much more, it doesn't take long, but we're going to go through that in a workshop and give you our tool and show you how to walk through it so that you can make these decisions confidently, quickly, and feel like you've thought through and you've seen pieces of it. You see how powerful it is from Martin. We're going to draw from those same concepts, where the Pareto principle, the 80-20 rule, where the money is and don't spend money where you're not going to get a sufficient ROI. So we're going to do a workshop on that, and for attending today, not only did you get the benefit of Martin and this tremendous, I'd learned a ton, and I've got more to learn from him, but we need him. But this is something that Timothy and I are putting on, and it goes with the international, and so it's considered worldwide, all the countries in the world. So you can discover how to engineer ROI into your international patent system, and whether you should file or not foreign. And so you can define your patent monetization strategy for selected countries. It's not just sort of, well, that sounds good, and maybe Canada, I don't know, maybe Japan, well, it's better. And then, so we'll do that more intelligently, forecast some cost estimates, which is normal, but we're all, what's really game changer, we're going to calculate your business ROI and the strategy, how you're going to get that ROI. And that's something nobody does. I've never seen anybody really do that systematically. And we'll give you a simple tool to do that, so you can confidently decide where in the world to file your patent profitably. Okay, so you can get your free ticket today for this to attend that workshop and get all the tools and the training. And that's coming up in a few weeks. And so the next thing is, if I can get my new share here. Where's my, yes, I think this is it. So just to put a bow on it, if you can see this webpage, want Martin's help? We have two programs, and we're gonna just do backup support. He's the main guy here, but UPC opt-out, yes, I want Martin's opt-out strategy, which he's said is very, very niche unless you have like a government contract, or UPC opt-out, no, I don't want, or I want Martin's no opt-out strategy, which is what he recommends for 99.999. And so get everything cleaned up so that you have everything, you're on top of everything. You have the bonus, it expires midnight tonight. If you want to sign up for that, there's the prices. You get our support and the $447 workshop ticket that's coming up soon. So that we're gonna, Hannah, can you drop the website link in the chat? And yeah, so there it is. It's upc.thompsonpatentlaw.com/offer-martin. So that's it. Any questions? Does anybody have any questions? Okay. Well, thanks everybody. Seeing no questions. Martin stayed up real late from his part of the world. We'll let him get some sleep. But,
yeah, we are used to that. Yeah, it's 2 o'clock in the morning now, but it's okay. We are used to that.
Thank you so much. And we're gonna probably do future workshops. I'm gonna try to get Martin to let us do future workshops on his conversion and his how to get a European patent in 12 months. So
yes.
So thank you so much.
Thank you.
All right.
Goodbye. Bye-bye.
Have a profitable day.
Thanks. Bye.
Bye. Goodbye.
Goodbye, everyone. Thanks.